All right, Mr. Is it Peppin?
Yes, ma'am.
Okay, this is your case. Can you let the court know what you're looking for?
Sure. I'm seeking actually treble damages. This is a professional management company whose lease blatantly violates the Landlord-Tenant Act. They should be clearly aware that it does. And this doesn't just affect me. This affects every single client that they have as a tenant where this is their standard lease. And these practices violate every single one of those tenants' rights. If the only thing you do here today is give me the damages that I'm already due because their lease is invalid and illegal, then there's a perverse incentive for them to continue to do this to other tenants. So if you agree that this is a violation of the law, then I think you owe me treble damages. They are a professional management company who is extending this to other tenants in their portfolio, and that can't be allowed. The other thing that I'm seeking is I do want, it's unfortunate that two individuals who are here probably can't do this. The individual who should have been here is the owner of the company. But I want to know whether or not this lease was written by the company or whether this lease was written by an attorney. That has two specific things on record in this court, and that is that once this court is decided, that lease needs to go to the DOL, who controls their license, who should admonish them for their practices because it's unfair practices and against a clear violation of the statute for real estate practices, which they can't violate Consumer Protection Act, which the Landlord-Tenant Act is. If the landlord wrote it, then he's inappropriately practicing law if he's not a lawyer. If a lawyer wrote it, then he needs to be reported to the bar for writing a lease that clearly violates Consumer Protection Act. So I would like on record who wrote this lease.
Okay, as far as what the court can do in district court here, especially small claims court, we can only do monetary damages. But when the defense are testifying, we can direct that question to them, just for the record, as you requested. On your damages, I have what you filed on the notice of what you're seeking. Can you walk me through all the different areas that you're seeking recovery on?
Sure. The Landlord-Tenant Act specifically has language that disallows the charge of professional carpet cleaning. The way the lease is structured and the way the lease is written, it's a mandatory requirement that the tenant professionally clean and provide a receipt to the landlord of carpet cleaning on exit. Now, I actually did clean the carpet myself prior to leaving the property, which is why it's not only just retaining the cost of what they charged me, but it's retaining the cost of what I paid. There is no legal requirement. There actually is a strict legal unrequirement not to allow a management company to charge a tenant for professional cleaning unless it's conditioned on the fact that that professional cleaning is actually required. It was not required when I left the property. And so I relied on what is fundamentally an illegal lease term to clean. If I rely on a legal lease term to clean the carpets in the first place because they cannot write it the way that it is written, it's absolutely blatantly against the Landlord-Tenant Act, then I have detrimental reliance on their lease, which I did. I detrimentally relied on their lease to do what I did until after I got the deposit statement back and I looked into this and kind of went through each one of these things to figure out, hey, this isn't the answer to the question. They can't charge beyond normal wear and tear. There was no beyond normal wear and tear, but fundamentally, the lease clause is invalid because it's illegal under the Landlord-Tenant Act. The language is forces a tenant, regardless of condition, to professionally clean the carpets. That's an absolute and blatant violation of the Landlord-Tenant Act, which specifically states you cannot force a tenant to clean a carpet unless there is a reason to force them to clean the carpet. And there was no reason here. Number two, in relation to the yard, I put in pictures. It's unfortunate that the way your system works is colored versions of the photographs don't show up. But you can see the yard, and there's an email attachment to this in relation to the yard where I communicated to them on October of my move-in year, which is only 2 months after I moved in, that the yard was basically dead when I moved in. You can see it in the pictures that they have in their move-in report, how many dead spaces there are in the yard, and it continued to be that way. Even at that time, I offered to do work on the yard. They didn't take that offer up. And I continued to do work because in the lease, if you look at the lease, it places that burden on a tenant. The problem with that is the yard was that way when I moved in. So I spent time, money, energy, and effort the entire 3 years doing post-emergent, pre-emergent. I bought I actually had it professionally aerated and professionally thatched. I bought a thatcher off of Amazon. I bought post and pre-emergent stuff. It was never my responsibility to do that. Again, only looked into it after the fact. That isn't normal wear and tear. The yard was that way when I moved in. I tried to do everything I could during my tenancy, including spending money on water, again, on all the materials, on all the equipment, on things that professionals came in and did, the things that I did. The only thing they ever did through the entire time is they had a landscape company come in and throw seed down, put no topsoil over it, didn't aerate, didn't thatch, just came in and threw seed down. And that's the reason why, if you look around the edges, that's what happened with the edges, is that they just threw seed down indiscriminately, didn't do anything for it. And so the edge work on the yard became a problem. They didn't do anything for the weeds. And if you look at the pictures from October of 2003, when I moved in, you can see the dandelions already starting to pop up. That just got worse and worse and worse over time. You can, even in their move-in report, the management company identifies a small amount of weeds. Well, those are the weeds that you could see at the moment in time. Weeds grow up over time and continue to pop up. And that's what happened in this yard. It just got absolutely out of control. I identified that at the very beginning of the tenancy. To charge me for anything related to the yard is a reach way beyond anything that the Landlord Tenant Act would allow. It was that way when I moved in. If nobody had moved in, which is the very definition of normal wear and tear, if nobody had moved in, the yard would have only gotten worse, and far worse than it was when I left. It was better than when I got there, and how it transpired to kind of come in over time as I ran through my tenancy. But it would have ended up that way no matter what. And you can see that in the pictures that I provided. That, again, it's unfortunate that you guys only upload black and white pictures. You really do need color pictures to be able to see just exactly how bad the yard was. But you can see it somewhat in the black and white pictures, how dead the yard was and how many dead spaces there are in the yard on my move-in. So any landscaping charges need to be returned to me. The other thing that they did in there,
I'm going to interrupt you for a second.
Yeah, absolutely.
Did you, you mentioned doing thatching and some additional work aerating. Did you have any receipts that you wanted submitted related to that?
I couldn't find them. I mean, again, it was over 2 years ago. I would have to really dig through like my bank account. When I aerated, I went through Lou Rents locally in Olympia. Maybe I could find that after the fact. I couldn't find it in time to submit it to you. I could certainly go look at Amazon, and you'll see in the email that I sent to them that I communicate that I already bought 2 bags of seed. Those seeds were bought at Costco for $50. That's what the seed cost. But it would be very difficult for me to go and find that again at this point in time. They're way back in bank records. So could I potentially, if you need it after court to provide you more information, maybe, but it would be tough to find stuff like that because of the time frame. We're talking 2 years ago, and I didn't expect to be required to keep these specific receipts in this specific instance. Like, again, when I was doing this, I was doing it based on the terms of the lease, which are illegal to begin with. They can't place the burden on me that they placed on me for landscaping that they did in the lease, based on the Landlord Tenant Act. So there would have been no reason for me at the time to think that I needed to keep any of these things. I just thought I was doing what I was required to do for the lease, even though it came to me that way. Like, I was worried that, again, I wasn't going to get my money back because the yard was bad, but it wasn't my fault the yard was bad. It started that way when I got there.
Okay. And then there was another issue, I believe.
So the other issue is cleaning. So they charged me for cleaning where, and they, I think in their move out report, they identified they had to screw in one of the screws in the sink, you know, the plunger that screws and unscrews. No damage, mind you, not damage to anything, that it was just unscrewed. If anybody's ever owned a home, their sink little thing is unscrewed over time. That's absolutely normal wear and tear, Your Honor. That there is nothing, no damage. They simply had to screw something back in. Like, the idea that that's beyond normal wear and tear is ludicrous. The other thing that they did is they charged me for a shower door, for cleaning a shower door. Hard water makes deposits on a door. Again, that's absolutely normal wear and tear. It's not something that's caused by a tenant doing something extreme. If by simply taking a shower, hard water deposits get on a shower door, that's absolutely normal wear and tear. That was charged as part of their cleaning that they communicated they needed to clean for. The other thing that they did is on the patio, they said that they had to have somebody come out because there was a green slime or mold or whatever on the patio. The patio is a wood patio with painting that needs to be repainted. The deck of that patio is exposed wood. It is a wood patio with bad paint that's outside in the Northwest. Over a 2-year period, if nobody lived in the property, the exact same thing would happen to that wood. That's the very definition of normal wear and tear. It wasn't, my tenancy didn't cause that issue. The weather and the fact that it's wood caused that issue. I can't control that as a tenant. So again, this is a professional management company that absolutely should understand beyond a reasonable doubt what the standard of the Landlord Tenant Act is, and they are enacting on tenants a standard that isn't remotely reasonable for normal wear and tear.
Okay, and so what I see on your summary is that you're looking for the wrongfully withheld deposit of $2,895, cost that you incurred of $653.20, and then you're seeking treble damages.
I think that's
correct?
Slightly inaccurate. I'd have to go back and look at the actual court filing, which I have up. I think I did bad math. It's actually $2,054.87 is the total, and I'm looking for treble damages on that $2,054.87. 600 of that is the time, energy, and effort that it required me to actually shampoo the carpets, which I shouldn't have been required to do, which was detrimental reliance on the lease and is strictly prohibited in the Landlord Tenant Act. And the remainder is the portion of my deposit that they held, which was for the cleaning, the carpet cleaning. They charged me for carpet cleaning, even though it had already been cleaned. Like, Your Honor, if you've ever had a carpet cleaned, you can walk into the property and see, and even in their own pictures, you can see the carpet marks that it clearly had been shampooed before they did, and they decided to do it anyways. That's completely on them. A, I shouldn't have been required to do it in the first place. B, they had no reason to shampoo those carpets when they moved in, so they charged me for that and for all the normal wear and tear that they charged me for. Additionally, in their packet, they include things that weren't included in the original move-in, move-out report. Those need to be summarily rejected. Number one, if you knew or should have known anything at day 21, you had an obligation at that point in time to move that forward. If you didn't move it forward, you can't move it forward now. That's the law. That's the law under the Landlord Tenant Act. And none of those things were brought up in the response in the original move-out report. The only thing that we can adjudicate here today is what was in the actual move-out report from them holding my lease. There are also some things in there that if you look at the move-in report, specifically page 81 of 105, they show they take a picture of the hinges of the toilet seat. Unfortunately for you, all these pictures are in black and white. Maybe on your side, you get to see them in color as we actually submitted them. If you look at the original move-in report, those toilet seats were vile. You can see the brown in those hinges in the original move-in report, and you can see them on page 81 of 105. That wasn't caused by me in any remote state. That was there when I moved in.
Okay. All right. I'm getting here from defense now. So I don't know who wants to go first.
Thank you, Your Honor. I'll go first. Sarah Black with Olympic Rentals. The property owners, Scott and Megan, are here as well. However, as Mr. Peppin indicated, we manage the property and represent the owners. with the tenant lease. I want to address everything that Mr. Peppin had touched on, and feel free to let me know if we've left anything out. First of all, with the carpet cleaning, had the carpet been returned in reasonable condition, we would not have had to hire a carpet cleaner to have it addressed. As noted on the invoice from Carpet Care, there was excessive soiling throughout the carpet. That included pet hair, major stains, food spills, and heavy wear patterns. That was the result of use beyond ordinary use of the property or wear and tear. I understand that Mr. Peppin had, or is claiming that he had cleaned the carpet himself prior to the move out. Unfortunately, if that is the case, those efforts did not reasonably address the dirt and pet hair that was present at move out. Regarding the yard.
Can I stop you for a second? Had there been a pet deposit that was paid or any sort of additional amount paid on the rent for having a pet on the property?
So Mr. Peppin's animal was actually an emotional support animal. And for that reason, we did not charge any additional rent or deposit.
Okay, go ahead.
Regarding the yard, at the beginning of tenancy in November of 2023, we actually aerated and overseeded the yard at Mr. Peppin's request. We do have those invoices if you'd like us to submit them, and we could do that probably fairly quickly. We'd have to pull the file. We also fertilized and applied a weed treatment twice, once in November of 2023 and again in April of 2024. Those treatments were at Mr. Peppin's request. We understood that when he moved in, the yard was not in stellar condition. There was some deterioration to the grass. It had died out over the summer months, and Mr. Peppin moved in right in the middle of summer in July of 2023. So we took those measures in order to help restore the condition of the lawn, and there was no requirement on our part that he do anything to increase the condition, only to maintain it in the state that he received it in. When he moved in, the flower beds were fairly free of weeds. I think there were a couple small weeds that were visible in the move-in photos, and the shrubs had also been pruned and the yard had been mowed. When he moved out, that was not the condition. There were weeds throughout the flower beds. You can see in our move-in and move-out comparison photos that the shrubs were also overgrown, and there was a bag of garbage that was left in the backyard as well. Those items were completed by Green Valley Landscaping, and that invoice was also provided Mr. Peppin on the move out, along with a move out statement, and that was provided to the court as well.
Okay. So the couple of issues like the cleaning, I noticed on the invoice that you provided, the billing was for a light clean. How is that not normal wear and tear?
So part of normal use of a property is also regular cleaning. You can see depicted in the comparison photos that we provided, the condition at move out was significantly different than what it was at move in.
I'm going to stop you for a second. You said part of it is regular painting. Are you saying that the tenants are required to paint?
Regular cleaning.
Oh, cleaning. Sorry, I thought you said painting. Go ahead.
And yeah, I think much of the work completed by the cleaner was probably on those shower doors. You know, if the water is not squeegeed off regularly, hard water stains do build up, and that can be time consuming to resolve. It was a relatively minor cleaning invoice. And there were specific areas that needed to be cleaned, which were recognized on the invoice.
So, can you walk me through what portion? So let me go back and find what the security deposit was and how much was withheld of it. That would be my question. Do you have, okay, there it is. Where is the, this statement related to the security deposit and what was paid, reimbursed or not reimbursed? I see statements and invoices on move out, but is there a specific breakdown somewhere in your exhibits?
Yes, exhibit 5 was our move out statement and the supporting invoices.
Right.
And on the first page there, you should see a move out statement deposit detail dated December 19th, 2025.
And you said it's which page?
It should be on the first page.
Well, the first page in our file is an envelope, so it's not that.
Sorry, it might be the second page then.
Okay. Page 2 to show up. I have move out statement deposit detail. That's page 3 in my file. So was there a refund issued in the amount of $1,493.33? Is that what you're showing?
That's
okay. And I'm going to stop talking to you for a second and say, Mr. Peppin, there's a notice on there that there's a City of Lacey sewer utility charge of $177.01. Are you disputing that? You're muted.
I am. They didn't provide any evidence that it was during my tenancy. And even today, which I can show you on camera, I'm still getting bills from the City of Lacey that have my name on them. And I haven't lived there since November. I've tried to call the City of Lacey multiple times. They won't let me change the account because the account's not in my name, but they keep sending me bills to my name on this property. I have a bill in my name for $300 currently with the City of Lacey because it's not being paid or somebody's not paying it. So I have no idea. If you look at what they provided in detail, they simply have billing statement, Nathan Peppin 177. There's nothing here from the city that communicates that this is my tenancy. In fact, the bill date is 11/28, the due date is 12/19, but there's nothing here that says this is from my tenancy. Maybe it's from my tenancy, maybe it's not. I don't know, but they were required to provide me something at move out that demonstrated this was in fact from my tenancy, and they didn't do that. That's the standard under the law. You fail to meet the standard, you fail to get to collect the money.
Okay. And okay, I'll go back to so can you continue? It's Miss Black, correct?
yes, correct.
So that shows on this move out statement that the move out date was November 30th. Is that correct?
That's correct.
Okay. All right. And do you want to respond on the City of Lacey sewer bill?
Yes, so the billing statement that we provided is the statement from the City of Lacey. And that is the same statement that Mr. Peppin is referring to, dated 11/28/2025. The City of Lacey's billing period goes through the 28th of each month. And so rather than prorating for 2 days on the following bill and waiting an entire month to finalize the move out statement and deposit detail, we billed through the current statement, which included almost the entire month through the end of Mr. Peppin's tenancy. If he is still receiving bills from the City of Lacey, we're glad to reach out to them and help to clarify that.
Okay. I'm just looking through all these bills, all these invoices that you submitted. Okay. Anything else you wanted to add on behalf of the defendants? Or did either of the other individuals want to comment?
Yeah, just two other things that I'd like to address that Mr. Peppin had indicated. He indicated that we submitted additional items to the court that were not previously presented to him. I'm unclear what that is. It's my understanding we submitted supporting documentation for move-out statement. There's no other claims that we are bringing forward. We didn't file a countersuit because he received a refund. So I just to clarify, we're not trying to add anything additional or recover any funds. And then also Mr. Peppin had indicated there was some cleaning at move-in that was incomplete. We were unaware of that. If there was, I wish we could have addressed it at the time so that that didn't become an issue today. But I'm sure what he was referring to in that.
Okay. All right. So, Ms. Peppin, it's your turn to respond.
The black bag in the yard was yard debris, Your Honor. It wasn't garbage. It was from me trying to do what I wasn't required to do under this lease. Again, if you look at their own documentation, I'm not sure, she's clearly not aware of what they submitted then, because if you look at their documentation, they literally have a specific document that says additional things that they added. Like the document in their docket that they submitted was additional things. Like that's what they submitted. If you look at the carpet cleaning, the only picture they have in the entire house of carpet, when there's only 2 rooms that don't have carpet, the living room and the kitchen, the family room, the upstairs media room, all bedrooms, the entire upstairs have carpet. They showed one picture, and in black and white, you can't even see. I don't know what it looks like in color, but they showed a place where a desk chair had been. This carpet is at least 10 years old, Your Honor. It's past its useful life no matter what. And they showed an area where a chair had been. Again, normal wear and tear is if you have an office in your building, you would have some normal wear and tear and some matting, and just matting it down. There was no damage to the carpet anywhere in that house. And after I got done shampooing it, based on the requirement in the lease, which is an illegal requirement, it is strictly forbidden in the Landlord-Tenant Act to require a tenant to professionally shampoo their carpets. And if you look at the lease states the tenant is required to professionally shampoo the carpets and provide a receipt. That absolutely violates the standards that exist in the Landlord-Tenant Act, which is a condition-based, not an regardless requirement. It has to be condition-based, and there was no condition that required the carpet to be cleaned in the first place. If we want to talk about the ESA, you'll note in their documents there's an ESA addendum. That wasn't signed. That wasn't signed because there was already pet smell and pet damage. And if you read the document that they produced a document that said the tenant verifies that there is absolutely no pet smell here. I had an argument with this tenant company, with the landscape company, or sorry, with the property management company at the very beginning. If you look in the move-in report, there are multiple places in the move-in report where a dog has chewed on the blinds. The property management company wanted to have an argument with me that was a kid that chewed blinds, that the kid would have to be at least 10, 11, 12. And they're running around chewing blinds by the front door, chewing blinds in the bedroom. There are multiple places in the property where the blinds have been chewed. There was absolutely and clearly an animal in that house prior to my tenancy. And as the shampoo smell wore off, you could start to smell it. I notified the property management company of that at that moment in time. The smell from the dog was not from my dog. I have a little 20-pound dog. My understanding is the dogs that were in the house before me were 2 large breed dogs. And if I need to, we can stay this court decision until I get affidavits from the neighbors, which will clearly identify the fact that there were large breed dogs in this house before I moved in. That's where if there is a smell from a dog, that's where that smell came from. Again, okay. I'm not sure about the utility charge, but all of the cleaning was absolutely normal wear and tear. The carpet was illegal, and the yard requirement is illegal under the Landlord-Tenant Act. If we want to take out the utility charges because we can actually prove that they were from my tenancy, great. But I don't know that that statement does that, but I'm happy to walk away from that. But again, when you have a professional management company putting terms in their lease that blatantly violate the Landlord-Tenant Act in relation to what the standard is that a tenant is required to meet, and then they charge tenants based on that requirement that they absolutely know or should know as a professional management company violate the Landlord-Tenant Act, this affects more than me, Your Honor. So I'll say once again, it requires the court to do treble damages. Is why treble damages are in the court system to begin with. A professional management company that blatantly violates the Landlord-Tenant Act and does that to more than me, you can absolutely guarantee that there are every tenant that is a member of this landlord company has the exact same lease provisions in their lease, and they have been charging tenants for these exact same things the same way they did to me. And simply because a tenant doesn't know they have the ability to come to court and to fight that, or doesn't have the ability because they've left the state, they need to be penalized in a way that prohibits them from doing this in the future.
Okay, thank you. I've looked over everything. And the couple of things I want to address. First of all, there is validity into several of the things that Mr. Peppin is saying. I've looked through the receipts. I don't see any evidence that there was anything beyond normal wear and tear to the carpets. Even on the billing, there's, discussion about pet hair and soiled spots, but there was an admission that there was a pet on the property. Normally when there's a pet, there's an extra charge for pets, and this was waived because it was an emotional support animal. So there is no evidence that there's anything beyond normal wear and tear. The statute on that is very clear that you cannot charge for carpet cleaning beyond normal wear and tear. The second issue is the cleaning. Even the cleaning bill says that it is a light clean. There's no evidence of anything beyond normal wear and tear on the cleaning. Then you go to any damages. The things listed as damages, again, are normal wear and tear issues that one would expect to find over the course of a tenancy that you cannot charge for. On the yard, this is one where there may be some dispute, but it appeared that the problems with the yard were reported to the landlord at the time of move-in. There was evidence that there was an issue before, no evidence that the issue was corrected. That's again something that would not go against the tenant because there's evidence of that. So I'm having a hard time seeing evidence of anything that would cause the landlord to bill for these expenses that are in clear violation of the Landlord-Tenant Act. I do find that that utility bill would be on the tenant through the end of November, which was when the tenancy ended. With regards to, so what was withheld was $1,461.70. Of that, the tenant does need to pay the $177.01 to the city of Lacey, or for that bill. I don't know if that's still owed to the city or if it's owed to the landlord. But that would be need to be paid. Then as far as the costs incurred that Mr. Peppin is seeking, that's a little more difficult. There was a requirement that there be carpet cleaning done on move out in the lease, which is in direct violation of the RCW 5918-280, which says you cannot charge for carpet cleaning. So I will refund the invoice for the carpet cleaning, which I believe was about $30. And then there was a labor charge, which I'm not going to allow that. But I will reimburse the invoice for the cleaning, carpet cleaning. Let me pull that up, which was I'll find that in a minute. I know it was
Can I ask a
about,
question related to that?
yes.
In their own documents, they charge me $75 an hour for labor. Nobody on their staff is paid $75 an hour. Even if you only took their estimate, that'd be $750. It's unfair to me to have me do all of that work and do my time and not be, I'm not even asking to be compensated at the level that they charge me. Like in their own documents, they're charging $75 an hour for the work that they're saying they claim to have to have done. If they're allowed to do that, why wouldn't I be allowed to claim my labor for the work that I did that was a detrimental reliance specifically on an illegal lease term?
Okay, Mr. Peppin, I haven't finished yet, so let me finish. First of all, I'm not awarding them. I'm saying that they are not going to get that.
No, I understand that, Your Honor, but you just said I didn't get labor, but they're charging people labor all the time.
I understand, but I'm not awarding that here. Okay, let me finish. So I am going to start with, they need to refund you your deposit that was $1461.70 plus the cost of the rental, carpet cleaning rental, which was $30.72. And then we're going to subtract the the City of Lacey bill. And then as I started to say, I am concerned because the provision requiring carpet cleaning is a violation of the statute of the RCW, is not allowed unless you can have evidence of something beyond normal wear and tear. And in this case, while there was some pet spots, it was a situation where the pet was allowed without an additional charge for the pet fee. So there's sort of an assumption of risk on the part of the landlord with regards to that. So I'm going to follow the provision of there is a discretionary award that I can make at 2 times the amount of the deposit when this was, it says when it's intentional. There is there's no evidence that it was intentional refusal to provide a statement, which is specifically what the statute says. But there is a provision in the contract that is a violation of the law. So I'm going to award some additional damages in the amount of $500, which takes the total award to Mr. Peppin to, sorry, my calculator just cleared. Okay, so it'll be $1,753.97. And so that is my decision. I will enter an order in that amount. And that will be available on the website by the end of the day? By the end of the day, so you can get that off the website. Okay, so that order's been signed and you guys are free to go.